If you're pregnant or on maternity leave and you feel like you're being treated unfairly at work, then you may have protections under pregnancy and maternity discrimination. In this video, we're going to walk through your rights, what the law protects you from, and what to do if those rights are being ignored. A 2016 survey by the Equality and Human Rights Commission found that 77% of mothers reported a negative or potentially discriminatory experience during pregnancy, maternity leave, or on their return to work. That's a striking statistic, and it's why understanding the law matters. Because the protections are real and they are strong, pregnancy and maternity discrimination means being treated unfavorably because you are pregnant, because of a pregnancy-related illness, or because you are on maternity leave. In certain circumstances, you also have protections in the sad event of a miscarriage. This has been unlawful under the Equality Act 2010. Unlike some other forms of discrimination, you don't need to compare your treatment to that of a male colleague to make a claim. The unfavorable treatment itself is enough. This protection applies during what's called the protection period, which runs from the moment you become pregnant until the end of your statutory maternity leave, or the date you return to work or leave your job if earlier. You have additional rights and protections in the case of a redundancy situation. Who is protected? The Equality Act is broad in who it covers. Protection applies whether you are a job applicant, an employee, a worker, or someone who is self-employed and personally providing a service. So even if you're not in a traditional employment relationship, you may still have rights, though your exact protections and rights can vary depending upon your employment status. What does pregnancy discrimination actually look like in practice? Some of the most common examples include being selected for redundancy because you are pregnant, being passed over for a promotion or job opportunity because of your pregnancy, being refused paid time off for antenatal appointments, being dismissed after announcing your pregnancy. These aren't edge cases. They happen regularly, and in every one of these situations, the law is on your side. Let's go through your specific legal rights as a pregnant employee or new mother. Antenatal appointments. Regardless of how long you've worked for your employer or how many hours you work, you have a statutory right to paid time off for antenatal care. Your employer cannot refuse this. Maternity leave. You are entitled to up to 1 year of statutory maternity leave, regardless of your length of service. Maternity pay. Statutory maternity pay is paid for 39 weeks for those who qualify. Your contract may offer more generous terms, so it's worth checking. Compulsory maternity leave. You must take a minimum of 2 weeks off from the date of birth. It's 4 weeks if you're a factory worker. Your employer cannot ask you to return before then. Keeping in touch days. You can work for your employer for up to 10 days during maternity leave without it bringing your leave to an end. Holiday. Your statutory annual leave, 5.6 weeks, continues to accrue throughout the maternity leave, both ordinary and additional. Pay and benefits. If your employer denies you pay rises, bonuses, or promotions as a result of your maternity leave, you may have a claim for discrimination or detriment. If you are dismissed while pregnant or on maternity leave, you are entitled to receive written reasons automatically, without having to ask, and regardless of your length of service. Breastfeeding. Your employer must provide adequate rest breaks and suitable facilities for breastfeeding mothers. A toilet does not count as a suitable facility. Flexible working. You have the right to request flexible working, and your employer must consider it properly using the required statutory procedure. Redundancy during pregnancy or maternity leave deserves special attention because the protections here are particularly strong. Dismissal or selection for redundancy because of pregnancy or maternity is automatically unfair. There is no minimum qualifying period of service required to bring that claim. If a redundancy situation arises while you are on maternity leave, your employer must offer you any suitable alternative vacancy before offering it to others at risk. You have priority. The new role's terms must not be substantially less favorable than your current contract. From 6 April 2024, this protection was extended further. Employers must now offer suitable alternative vacancies from the moment you inform them of your pregnancy, and this protection lasts until 18 months after the birth. That is a significant safeguard for women returning to work. If you believe you're being discriminated against because of your pregnancy or maternity leave, the most important thing is to act quickly. Employment tribunal time limits are strict, in most cases 3 months, though this will be changing to 6 months in the future. And you need time to go via ACAS first. Keep records, document conversations, emails, and any decisions made about your role, and seek legal advice as early as possible. The sooner you do, the more options you will have. Pregnancy and maternity discrimination is unlawful. It is taken seriously by employment tribunals, and you have real, enforceable rights. Whether you're still pregnant, on leave, or recently returned to work, if something doesn't feel right, trust that instinct and seek legal advice from Duncan Lewis today.